Hello, everyone. Welcome to another one-on-one Talking Feds. We've just gotten the petition for cert from Donald Trump to the U.S. Supreme Court from the Colorado case, holding that he was not qualified to be listed on the ballot. So I immediately thought of my friend and occasional colleague, Rick Hassen, who is a professor of law and political science and the director of the Safeguarding Democracy Project at UCLA Law School. Rick's the author of over 100 election law pieces in important journals. He's been named one of the 100 most influential lawyers in America. A perfect guy to talk to about the cert petition and how the case from Colorado and potentially other states is shaping up. So, Rick, thanks for being here.
Great to be with you.
So let's just start with a general professor's critique, as it were. I think Trump has very spotty lawyering, some good, some bad, some all political, which I guess is both. The cert petition itself, how solid a piece of work would you say it is?
Well, so the first thing I'd say is that it is much better than the kind of Kraken lawyering that we saw after the 2020 election. Those cases lacked facts. They lacked legal theories that were plausible. The last time that a Trump ally went to the Supreme Court in a case as high profile as this was with Texas, where Ken Paxton filed that brief trying to get a bunch of other states' electoral college votes thrown out. That was, I think I called that hot garbage. This is not that.
Yeah.
So by those standards, this is great. I agree with you that some of the arguments are stronger than others. I should say that there is a separate petition that was filed by the Colorado Republican Party.
Right.
These things will eventually be consolidated into one case. And if you put them together, perfect lawyering aside, they raise substantial, serious questions.
Yeah, I'll say the same. Look, remember, this is a special function of just getting the court to accept it. Republican Party has already weighed in, as have the winners, who said, yeah, do it. Court, take the case and do it super quickly. They've proposed an amazing kind of warp speed on steroids schedule. But the Republican committee proposed a quick one, and Trump just said, do it quickly. So I think it's a solid job. Again, it's just serving up different questions. It does an overall question of did Colorado get it right? But I think if the court takes the case, they'll frame the questions they want the parties to consider. So let's just start with so he's got several claims in there. Some, as you say, stronger, some weaker than others. He begins after some very political bromides, you might say, or peons to the political process. His first real argument has to do with the political question doctrine and judicially manageable standards. That's something that comes up in election law cases, for example, in the gerrymandering cases. Can you just give us a sense of what that is and why he is leading with it?
Sure. And this argument is one that the court is familiar with.
Yeah.
But before the 1960s, the Supreme Court wouldn't entertain claims that when districts were unequally drawn, the so-called one person, one vote standard, they used to say, well, we don't have standards to do this. There are certain criteria. I think the court came up with 6 for when it decides something is a political question. The easiest example is the idea that the Constitution sometimes gives other branches the power to do things. So, for example, the Senate gets to try impeachments. And so the Supreme Court's not going to weigh in and say, did the Senate get it right when it decided whether or not to convict someone? Yeah. So one standard is, it's committed to another branch of government. Here, part of the argument is it's really up to Congress to decide whether or not someone's disqualified. There's a part of Section 3 of the 14th Amendment that allows Congress to lift disqualification by a 2/3 vote of someone who's been disqualified. There's that. There's also this idea, as you mentioned, there's no judicially manageable standard. Back in 2019, the Supreme Court rejected an argument that partisan gerrymandering could violate the U.S. Constitution. It might, in theory, violate the Constitution, but the court said, we don't know how much taking party into account is too much. So the argument here is kind of a combination of those two things. It's given to Congress, and it's not for the courts to say what disqualification is. It's certainly not for a state court judge, or if you take a look at the main case that's working its way through the system, it's not for a partisan Secretary of State to make these decisions. It's really up to Congress. If you combine that
let me stop you here and zero in on what seems to me to be two possibly separate arguments encapsulated in what you said. So the first, what they really said in the gerrymandering case is we don't know what to do. There's no judicially manageable standard. Two little points about that. One is, I mean, really, how hard is it? It is the sorts of things that courts do all the time to say, was it something an insurrection? Maybe they need a definition. What did someone engage in it? Did they take an oath before? So that doesn't seem so difficult, at least to determine. But the second point is they could be saying in the gerrymander case, they basically said, we don't know what to do, so we give up. That's a pure political question. But as I understand it, correct me if I'm wrong, that's not a doctrine that binds state courts. That's for federal courts, and there's no reason that Colorado would have to follow it. So in that sense, if you're the Supreme Court looking for a uniform federal solution, it's maybe inapposite. The other thing they could be saying, and that seemed part of what you were saying, is that by its very terms, just as by its very terms, the Constitution says Senate will try impeachment, by its very terms, somehow Section 3 of the 14th Amendment says, through interpretation, that this is Congress's job. And if that's a positive constitutional command, you would think the states can't violate it. Does that distinction make sense? And do you think it's in play here?
It does tie into another one of the arguments, which is that Congress has to pass a statute that would authorize the states to do this. And that would be a way to kind of marry those two things. There was also a brief that was filed in the parallel Colorado case by the National Republican Senate Committee, Steve Daines, which basically says, it's not the exact same argument, but it's close enough. It says that the question of whether or not a person is disqualified is about holding office. It's not about running for office.
The word in the actual section, as it were. Yep.
So the idea is let Trump run. By this logic, I think you'd have to let a 32-year-old run, and then it'll be up to Congress to say, no, sorry, you're not qualified after the fact. So that's a way to kind of punch this down the road. I think it's extremely dangerous as an argument, because the last thing we want as a country in terms of political stability is we hold an election, Trump versus Biden round 2. Trump appears to win the Electoral College. Democrats control the House, and they say, you know what? Trump's not qualified. He can't be president. I mean, that's a
By the way, the House or the House and Senate, by hypothesis, would you say they'd be saying?
Well, if the House and Senate don't agree, then we get into all kinds of rules on a contingent election.
Yeah.
I'm imagining a scenario where the House is controlled by Democrats. Maybe the Senate is too, in which case, Biden remains president. That's possible. Or they don't agree, and then, there's all kinds of rules about how that gets resolved. One of the possibilities is what's called a contingent election. But there's no veto
here, right? It's a congressional determination is by hypothesis that the court is saying. It doesn't then go to the president to... it's not like a bill. It's a congressional determination.
Right. Right. But, you can imagine if there's a dispute over whether Trump is disqualified, then someone tries to go to the Supreme Court, and is the Supreme Court going to get involved then? Yeah. Not if they've said it's a political question. So right. There's just, if you try to draw a decision tree, how the court could go in this case, there are just so many off-ramps. There are so many different branches, so many ways the court could go. It's hard to know how they're going to think about this, how they're going to structure things. Yeah, and how much politics will play a role in this.
And let me speak to that in particular, because there are politics and there are politics. So one way of thinking of it, as many people did say Bush v. Gore, is, will the good Republicans vote for the Republican candidate? I think there's another sort of higher notion of politics here, which is, man, they don't want to carry the burden on the court for deciding. and there is what they think is the best result. Let's say by hypothesis here, it's that no state gets to decide. So there's not a patchwork solution. And now they get together and sort of all decide as close as they can to unanimously the right rationale, even if it's not what they would do under a pure analysis in a less important case. But I think that brand of politics would be in play, as well as, the sort of normal thought of just down and dirty politics. Can I just check that just as a fact, that first point, am I right that the political question doctrine, in the sense that it was used as decisive in the gerrymandering cases, is not a justiciability doctrine that is controlling on the states? That if that's really where they're going, the effect would be to say, we're out of this, but that doesn't overturn what Colorado had to say?
I think that's right, if it's just an application of that doctrine. I mean, you can look at partisan gerrymandering cases after Rucho. The Supreme Court said that those cases are non-justiciable political questions in federal courts, but state courts have come in and said it falls under our state constitutions. So yes, if it's that standing alone. So I don't think that alone is going to give the uniformity.
Let me jump to I probably should have started with this. Do you share my instinct that the court here, for a welter of reasons, will in fact be casting about for some uniform federal solution that has Trump on the ballot in all 50 states, assuming he's the nominee of the Republican Party?
I think that's probably the second thing on the list. And the first thing on the list is not having a 6-3 decision with all the Republican appointed justices coming out one way and all the Democratic appointed justices coming out the other. So I think John Roberts and probably some of the other justices, I think maybe Justice Kagan, Justice Kavanaugh, the ones who are concerned about the court as an institution, are going to be struggling mightily to find some path for a 9-0 or 8-1 or something like that. What exactly that looks like, that suggests punt. So if they follow, say, the argument made by the Republican Senate committee that kicked the can down the road till after the election, if the Democratic appointed justices are on board with that, that would be a way to not weigh in on the merits and then deal with it later.
Well, wait, is that right, Rick? Would that have the provisional solution of keeping Trump on the ballot everywhere? What exactly would the legal ruling be?
It would be that the Section 3 is only a bar on holding office, not running for office.
I see.
And therefore, you have to let him run for office, and then it'll be determined at a later date by Congress or some other actor as to whether or not he's actually entitled. Right. Is the court going to want to weigh in on whether or not Trump engaged in insurrection? Hard to imagine Justice Sotomayor and Justice Alito agreeing on that question.
Hard to imagine they have the competence to do it. They're not fact determiners, right?
Right.
What would they even do if they wanted to? So that strikes me as also once you think about it, not a very good choice for them.
Well, so, normally a district court, a federal or a state court or a jury engages in fact-finding, and that fact-finding is reviewed for clear error. The court's used to doing that in election cases all the time. There are cases called racial gerrymandering cases. There are different partisan gerrymandering cases where the question is whether race predominated in drawing district lines. And the court says, we're going to review that for clear error. We're going to defer. So maybe they defer to the determination of the state court judge in Colorado, but Trump has argued
that would mean they would uphold his exclusion from the ballot. So principle 2 then would be in peril.
Yeah, but even before you even get there, Trump has made due process arguments, which the dissenters in the Colorado State Supreme Court agreed with, that he didn't have enough chance to defend himself. So you could say that someone who engages in insurrection is ineligible to be on the ballot, but how do you know if someone's engaged in insurrection? What's the standard of proof? There's an argument that has to be clear and convincing evidence. How do you decide all this? So that's what I mean when I say there's so many off-ramps here. There's so many ways they could punt. My hope is that they don't punt and we do get some uniform standard for the sake of stability of the country.
This really is a case where there's not much law to go on and stability of the country is at issue. And to take your point, Rick, just now, if they could say something like that, but then a state among the 17 that are considering would say, "Thank you very much, Supreme Court," and based on that, we find he engaged in insurrection, and they don't have the uniform solution. I think when they bear down on these different possibilities, a lot don't commend themselves very much. And let me move to another that I think is in this category. They resurrect the electors argument that we thought was cabined to Bush versus Gore, but has been seen the light of day a little bit in recent years, where basically, the best I can state it is because of the mention of state electors in the electors clause, if a state court too much departs, whatever too much is, from state law and practice, there's a federal question. That strikes me as the clearest case that the progressives would never go along with, and that's a recipe for a black eye and a 6-3 decision. Would you agree?
I think that was the weakest of the arguments in the brief, because the Supreme Court has, since the last time Trump tried to raise these arguments, decided a case called Moore versus Harper, where the court really cabined that kind of argument. So, I can't imagine the court going that way, and I agree with you that there's no way that if the court is looking for unanimity or near unanimity, it's not going to say that the procedures by which the state court found Trump ineligible arrogated the power of the state legislature, because it looks like Colorado does allow its courts to adjudicate these things. And so what if she took more than 5 days to reach her decision? Like these were really technical, minor things. I can't imagine
and
the case
state
turning
law,
on that.
right? It seems to me, I just think it's hard to say that there's process permitted for that. Courts do this, and indeed they keep presidential candidates off the ballot. You just haven't had a whole nationwide candidate. We got one more left out there as a candidate for a uniform federal rule that knocks all the states out of the business here. It's not one that's had great enthusiasm from the commentariat, but it's the one that the trial court in Colorado chose, finding that Trump is not an officer. So it's almost a one-off case where 14th Amendment Section 3 just doesn't apply to somebody running for president. What are your thoughts about that, both on the merits, but also its likelihood of being embraced by the court, given the criteria that you've already identified?
Well, there are some originalist scholars who disagree on this point. And,
Right.
You've got Josh Blackman and Seth Tillman and Steve Calabresi on one side. You've got Will Baud and Michael Stokes-Paulson on the other. And I mean, I'll let the originalists hash it out. I just find it fundamentally absurd, this idea that it's so important to disqualify people from serving in office who participate in insurrection. We're going to have this blanket ban that requires a 2/3 vote of Congress to restore someone. And this is going to apply to every office in the land, except for the most important one. I mean, that seems to go against, you should interpret constitutional provisions and statutes to avoid absurdity. This seems pretty absurd to me. Is it a technical way that some of the justices might be attracted to? Sure. But it really does seem to me to be nonsensical.
Yeah, it'd be funny. I guess it's sort of a question of how do you gauge the political capital of the Supreme Court? Is it based on their, persuasiveness, or is it based on their degree of intervention? Because this is about as good as it gets for a clean, doesn't interfere with anything else. But yeah, I think a lot of scholars and other people would be holding their nose. Okay, so first, besides that, I think we've touched on most everything. There's a mess of state law claims, not even under the electors clause, that they didn't comply with Colorado section blah blah blah, which I think are non-starters. Do we have now all the candidate questions or ways of reversing on the table? Have we missed any?
Well, the other one that was in the Colorado brief, and just before we came on the air, Trump filed a letter saying that, he's not going to respond, but it's the First Amendment argument,
Right.
which is that Trump was engaged in speech. That speech did not rise to the level of inciting imminent violent action under the Brandenburg standard. And therefore, what he did was protected by the First Amendment.
Right.
We've got to get pretty far down the road for the Supreme Court to be addressing that question, right? So they have to determine that, this is self-executing. It applies to the states. It applies to the president. Trump engaged in insurrection, but his conduct is protected by the First Amendment. Like, lots of things would have to fall in line for the court to reach that issue. And it does seem to me to be a fact-based question. Again, how much does the court want to weigh in on the question of whether or not Trump engaged in insurrection? So, I don't see it likely going that way. I see it much more likely being a technical way.
Unlike other areas, there's case law here that they'd really be swimming upstream against, whereas in other ways, they're writing on a blank slate. I think that's a mixed metaphor, but you know what I mean. All right, so let's see. Have we identified two lead candidates? Let me try again to refine or make sure I understand this first one well. Are there two questions or one? Two ways, two different legal issues and ways of reversing, or one here in the notion that the Congress is by constitutional command implicit in the 14th Amendment required to take a vote. That's the only way. It's not self-executing. Rather, Congress must decide. That's one. And then second, there are no judicially manageable standards. It's the sort of thing that Congress must do. Do you see that as two separate arguments and each viable and in play?
Yeah, I do think they're two separate arguments. You can say it's a political question without Congress having to do something first.
Right.
You could say it's a political question because it's given to Congress, or you could say it's a political question because there are no standards for courts to adjudicate these issues. So I do think they're separate. They obviously overlap, but the court could address either one of them. One of the things that we didn't talk about is Trump's question presented.
Yes.
At the very beginning of a...
Let's talk about questions presented and what you think the court will do if they decide to take the case.
So usually what happens is when a party files a cert petition, they list a question or questions presented.
Right.
So here are the issues. So in the Colorado brief, they mentioned three. The First Amendment argument I talked about a few minutes ago was one of them. Trump's brief did something a little unusual in that they have a very general question presented. Did the Colorado court, I'm paraphrasing, did the Colorado court err in disqualifying Trump? And so within that are all of these subsidiary issues.
Yeah.
That's kind of like a mess for the Supreme Court. And so it's hard to imagine they would, if they're going to take the case, which I think they are, that they would grant cert without reframing the question.
Yeah.
And what would that reframing look like? I think it would deal with discrete issues like the ones you've raised.
So you see them issuing an order we accept, and here are the two or three questions presented we want the parties to brief. Yeah.
Yeah, I think so. As we're talking, one of the things that occurs to me is I wonder if the Department of Justice is going to file a brief in this case.
Or be asked to. Yeah.
I recently wrote an amicus brief in a totally different case where the Supreme Court said, we like the questions presented by the Solicitor General, so we want you to brief those. So something like that could happen here too.
And it'll be an important indication, right? I mean, look, I think what we're positing in our discussion is they'll be pretty interested in going a certain way, bottom line, but really struggling with how to get there, both for adequate legal cogency, if not perfect, and for avoiding an ugly divide in the court. So they know better than any of the parties what are the candidate questions.
Right, and it's not like they're like behind a veil of ignorance. They know what they're going to want to do. I'm sure they're exchanging memos or at least exchanging views and strategizing. So we can learn something potentially from how they write the questions presented.
Very much so, right? I do think they're likely to identify two or three, and I think we've I think we've at least identified the two or three most likely because They need a uniform federal solution. I think all 9 of them will pretty much be on board with that idea. I can't imagine anyone, I could be wrong, but it would strike me as very remarkable if there was sentiment on the court for a patchwork solution. And it's almost impossible to unfathomable that there would be a uniform federal solution of just boom disqualifying him from the ballot. So I think they may be even as divided and polarized a court as they are, of a relative like mind. I can imagine certain things generating nasty dissents from Alito and Thomas, but they would want to avoid that if they could. So maybe they'll, like, for instance, I agree with you. Yeah, definition of insurrection and even more so engaged, those aren't going anywhere. And the electors clause, that's not going anywhere. So we may know a lot more if they issue it. They may actually call it down to 2 or 3. And they'll want to hear from from what the parties have to say on those and only those.
Yeah, and I think that again, John Roberts, being the institutionalist, is
Yeah.
going to look for some kind of path for consensus. And what worries me is that if that path for consensus is kicking it down the road,
Yeah.
we might have more trouble down the line.
Yeah, you've spelled out an absolute disastrous scenario. I mean, that's the funny thing about so many of these legal issues. They have broader implications. You don't want to be too flip about talking about the importance of a case, in Civil War terms, as if it somehow trumps what the legal right answer is. But if and when you do, this could well be one of the cases. All right, I know you're mainly an election law specialist, Rick, but not a Supreme Court practitioner, but you know the court. So let's say they agree that they want to do it quickly. What's your sense of how fast this can move and what will happen next?
Well, the next thing that's going to happen is there will probably be motions to expedite in the Trump case, as there were in the Colorado case. There will be.
Well, you're assuming they take it right away, you mean, or?
No, I'm saying the cert petition. Trump just filed the cert petition as we're recording. It just
Right. Oh, I
got put
see.
on file, and so there's going to have to be a motion to expedite that case too. So I
But
think
I'm sorry, isn't that case already a motion? There's already a petition for cert in that case. It's just by another party, and it includes a motion to expedite. Now, even if Trump hadn't filed yesterday, they could take Trump's case, could they not?
They could, but the cert petition was just docketed with a response date of February 4th.
Oh, I see. Gotcha.
So there's got to be a motion to expedite there. I think within the next few days, there'll be enough filings that the court could issue an order and consolidate. We're at Thursday, so I'm guessing, as we're recording, I'm guessing by the middle of next week, the court's going to announce something in terms of timing. And I think it would probably be something over the course of weeks. Voting, remember, is going to be starting in a couple of weeks. So I think that adds to the urgency. Unless the court knows it's going to kick the can down the road till after the election, in which case they might give more time.
That's interesting to see how it develops, because they know at least more things are coming. But okay, so, and if they go fast, and I'm thinking of cases where they've gone fast, they give a couple weeks for the merits brief by petitioner, a couple weeks for respondent, a couple days maybe for reply, and then they hear it mighty quick.
Yes,
they could
also
March,
hear.
Yes, and they issue an opinion. Who knows? But shortly thereafter.
Yeah,
they could, right? Yeah,
they could go faster. Trump's brief asked for summary reversal, not even oral argument.
Right.
Remember in Bush versus Gore, it was 36 hours from the grant till oral argument.
I just noticed an aspect there that I hadn't realized. I assume the Bush team blundered and just did a motion for stay, and the court actually construed the motion for stay as a petition for cert and then granted it. So when they want to blow through things, they can certainly do it.
Right there, of course, there was an imminent deadline for the states to finally certify their electoral college slates. Right. So that was the rush there. Here, the way the stay is put in place in Colorado, Trump's going to be on the ballot. So, the court could dismiss the whole thing as moot and say, come back when he's disqualified from the general election ballot. That's another way the court could duck this issue for a number of months. Wait till he's the
that's
nominee.
got to be not good for it, right? The longer they go, the more they're going to be intruding on the election. No?
Yeah, sure. But I'm saying that they could.
Yeah.
If John Roberts' primary thing is unanimity, one way to get unanimity is to defer.
Yeah.
So, I don't know. But the point is, they could act in a number of days if they felt they needed to. I think it's more likely we'd be talking about a number of weeks rather than months in this case.
Very good. And it may well be that whatever impact it has, there have been different courts giving punting in different ways because of the nature of a primary versus a general election. It may be already that it's too late to do well, given that there is no state now. They're moving through in Maine. They've got to stay in Colorado, in which he's off the ballot. It may be that whatever they say will really come to the fore in the general. But I do think they're kind of stuck. Not the and of course there are a couple other cases that may be coming right their way in the election. They're acutely aware of the stakes for the country, but also for the court. So this is quite the unusual Supreme Court case, and its combination of importance and open-endedness, unsettledness of the law.
Yeah, let me just make one more point, which is
Please,
that the longer this goes, the greater the risk that Republican voters are being disenfranchised. So if you're a Republican voter and you're deciding, say, between Nikki Haley and Donald Trump, you might think, I like Trump better, but I don't want to waste my vote on Trump if he's not going to be the nominee. I'd rather have Haley than Chris Christie, for example. The longer this goes on, the longer there's uncertainty as to whether or not Trump is allowed to run and can hold office, the more there's the risk of disenfranchisement of these voters. And I think these voters need to know, is the person I'm thinking about supporting eligible to be president? And so that's, I think, another reason why we need a quick resolution of this question.
Great point. And of course, another downside of the kick the can down the road possibility you raised, that people could vote for him and then he'd be ousted between November and January. Can hardly imagine. But there's been some events of the last couple of years that would have been hard to imagine ex ante. So here you go.
Yep.
Rick, pleasure to talk to you. I hope we can stay in touch as the petition unfolds and the eventual decision. But really appreciate your vantage point and expertise.
Great to talk to you.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.